actually came in through the state because we came up and checked it.
Was it a different number through the state?
I don't know the number, but she came up, checked it, and said it came in through the state, and you didn't want to duplicate exhibit, but she didn't. I don't have the video, so.
Okay.
We'll just make sure.
Make sure, yeah. Any other issues? All right, State, you may proceed with your closing argument.
Thank you, Judge. Your Honor, the test of the fairness of any judicial system is whether it can treat everybody the same. And here inside the four walls of this courtroom, nobody should be above the law. In this country, in this state, in this city, as Chief Eden said, the police must abide by the same laws they enforce on us. And so that's where we start, with the fairness and the fact that no one is above the law. What does the law say? I think we've proven what we told the court the law says that applies to everybody. The way we started in opening statement, you don't get to claim self-defense if you start the fight, which happened here both at the beginning with the open space officers, and again when now, as Officer Weimerskirch has admitted, he invited Mr. Boyd to come down, pick up his bags and come down, and they attacked him a second time. You don't get to claim self-defense in that circumstance. Whether you're a police officer or a citizen, you don't get to claim self-defense if you create the danger. And that's what happened here in this case. Mr. Boyd did not advance on these officers. The officers advanced on Mr. Boyd and went from being in a safe area to an unsafe area. And finally, Judge, probably and most importantly, you don't get to claim self-defense if the victim poses no threat at the time that you shoot him. And this picture is taken before any of the 6 shots are fired, Judge. This is the picture of what all three officers have now testified they saw before the first shot was fired. Keith Sandy in his statement said, "I saw him turn to his left." Richard Ingram said he saw him turn to his left. And Officer Weimerskirch, even though he didn't say it in court initially, that's what he told the briefing people the very night this happened, that he'd seen him turn to his left. I think Sergeant Fox said, whether he's a danger depends on who's up there. There was nobody up there. He was doing what they told him to do at the time and posed no threat at the time they fired the first shot, the second shot, and the third shot that hit him. There is probable cause that this was not justified, just as we said we would prove in opening statement. What has been the defense response? Well, they have brought in every officer who was at the scene, and they all say the same thing as we, I think, predicted in opening statement as well. It's this, the Tueller drill, the Tueller drill, the Tueller drill, the Tueller drill. The consistency of their testimony is understandable. They want to protect their fellow officer. There is a blue wall of silence that they want to protect and not have somebody indicted when they shoot in this particular situation. The most interesting thing is the one person who did not hew to the line that everybody else was towing, and that was Sergeant Jim Fox, who came in and said to you, when presented with somebody turning and then with somebody turning their back to him, that he would not shoot. And he's one of the people that trains the APD officers, that then they are not a threat to you if they are turning away from you, if they're doing what you say and they're turning away. You do not shoot them in the back. That is against protocol. But there was an even more interesting person who said, it's not the Tueller rule. The fellow that came in here who is the apologist for the police officers, Bill Lewinsky, the fellow who defends police officers in all kinds of circumstances. And we found in his own writings, in his own words, what he says the Tueller rule says. And here is what he says. The distance of a person with a knife cannot be the factor upon which a police officer decides to shoot. A person with a knife cannot be considered an actual threat justifying deadly force until he takes the first overt action in furtherance of his intention, like starting to rush or lunge towards the officer with intent to do harm. And even then, there may be factors besides distance that influence a forced decision. And here's the most important thing he says, Judge. So long as a subject is stationary or moving around but not advancing or giving any indication he's about to charge, it clearly is not legally justified to use lethal force against him. And that's the very circumstance that we have here. James Boyd did not only never advance or give any indication he was about to charge. At the time he was shot, he was turning to follow APD's orders to get on the ground. And that's obvious from the videotape. Not only is it not justified based on the tool or drill, it does not fit into any of the categories in the justifiable homicide by police officer instruction, which is UJI 145173, which says, justifiable homicide by a public officer or a police officer, there's a number of categories. The only one that even remotely is close to our case is this one. Only if it is committed while arresting Boyd for a felony and he is fleeing from justice, which is Tennessee versus Garner. That's the only part of the UJI that would make this justifiable shooting by a police officer, but it combines that with something else, Judge. It says also, a reasonable person in the same circumstances as the officer would have reasonably believed Boyd posed a threat of death or great bodily harm to another person. And those two things have to come together for there to be a justifiable homicide by a police officer. So, first of all, what was the charge? Was it a felony? Well, first of all, was he fleeing from justice? Let me start with the very first part of that thing. Was he fleeing from justice? Again, Sergeant Fox said when he was on the stand, Boyd could not have fled. We had established a perimeter. He could not escape. So he was not fleeing from justice. And as we know from the videotape, not only was he not fleeing from justice, he was turning and then completed the activity to lay on the ground. He was surrendering. He was laying on the ground and doing what the officer said. So this justifiable homicide by a police officer instruction doesn't apply because he wasn't fleeing. But what was he charged with? In truth, Judge, oh, this is the thing showing that he was surrounded and couldn't get away. As much as they want to make this a felony, Judge, they were up there for a misdemeanor illegal camping citation. That's what they were up there for. And the appropriate way to have handled that came from Sergeant Chris Ware from the New Mexico State Police, who said they should have dealt with this by telling Boyd to move his tent 300 feet away to national forest land. Had he just moved 300 feet, had they just gone up and said, look, you can't camp here, you got to move your stuff, we're going to come back tomorrow and check, you have to be out of here by then, none of this would have happened. It was a misdemeanor charge, and I know they keep saying, oh, it was no, he attacked the police officers, but had they charged him with the felony of aggravated assault on a peace officer for pulling out his knives in self-defense after the officers pulled out his gun, here's the instruction he would have been given in that circumstance. There's an instruction if you're charged with aggravated assault on a police officer that says defense against excessive force. A citizen has the right to defend himself against an officer using excessive force. Excessive force means greater force than reasonably necessary. And at two different occasions, they used excessive force on him, both at the beginning when these officers pulled their guns on him within 11 seconds of contacting him, and then again when all of these people surrounded him and lined up and used excessive force against him. And the two important times when he pulled out his knife is the first time that excessive force is used on him, when the guns are pulled and he's doing nothing, being completely cooperative there at the campsite. And then again, at the end, when he has his knives put away, he puts his bags on, he's coming down, they attack him again, and he only pulls his knife out again in self-defense when the dog comes up to him. And you'll see in the video, Judge, the dog comes up. I don't think the dog ever bit him because there's no wounds from the autopsy on that. Dog runs up, turns around, and comes back, and that's when he pulls out his knives again in what Officer Sandy accurately describes as a defensive gesture, not an offensive gesture, but a defensive gesture. But there are more rules. And I don't think you have to be mentally ill to think that you were acting in self-defense in these particular situations where there's excessive force by a police judge. One of the interesting witnesses in this case was Alexander Thixton. He is the neighbor who called the police rather than call social services. Alexander Thixton, when police came to his home, was in fact armed with a deadly weapon. He had a pistol that was concealed on his person. He had taken that pistol along with his two Great Danes up to the campsite to check out the campsite before this, and he did not tell the police officers that he was armed with a deadly weapon. And when the police came to Alexander Thixton's home, they certainly didn't pull their guns on him in 11 seconds, nor did they even ask him whether he was armed with a weapon. And when I asked Mr. Thixton about why didn't he disclose to the officers that he was carrying a gun, he seemed really put out by that, almost outraged by the fact, that the suggestion that he should have had to tell them that he had a gun, because he said, just like Mr. Boyd said over and over again for 2.5 hours, he had a legal right to carry this concealed weapon, just like Mr. Boyd had the legal right to carry pocket knives that he used for tools when he was camping. And that's what the law says of self-defense. 145190, a person who is threatened with an attack need not retreat. In the exercise of his right to self-defense, he may stand his ground in defense and defend himself, particularly when he's in his own home, just as Alexander Thixton was when they came to his house, and Mr. Boyd was when they came to his tent himself. So there is no felony in this case. Finally, the jury instruction talks about what a reasonable person is. A reasonable person in the same circumstances as the officer would have reasonably believed that he posed a threat of death or great bodily harm. Different than what, and this is different. What officers were trained to do. And that can't be the law. I think it is probably appropriate that this case, this preliminary hearing, will be decided on the 10-year anniversary of the John Hyde shooting, where 2 officers were killed, officers Michael King and Richard Smith, along with 3 other people, by a mentally ill man, not with a knife, but with a gun. And since that happened 10 years ago, the pendulum has swung way, way too far, Judge. Both training of APD officers has created this unreasoning fear in these officers, I think typified by the videotape that you finally stopped them from playing in the court, that would scare young officers to death with the kind of, it was like a slasher video where they have people, you know, stabbing people through the window with knives, and then a blonde woman with in a fur coat with a driver's license with a razor on it. And I suspect that's never happened in the history of this nation, that some woman has a razor that she attacks the officer with. That's the kind of stuff they are training people with, and you've got to be on guard, and everybody's a threat, and danger, 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 danger. In fact, their own witness put on, Ron McCarthy, the actual statistics about police officers who are killed with knives. He had a 10-year period of time in which 594 officers have been killed. Only 7 of them were killed with knives. That's the real danger to police officers from knives, rather than this made-up danger. And knives are not as dangerous as guns. If that were the case, if they were treated exactly the same, they would stop issuing police officers guns and just give them knives. Here in Albuquerque, as a result of what happened with John Hyde 10 years ago, the population that has suffered the most is the mentally ill population, part of the population that James Boyd was with. And it should not be police training or how they scare these officers that determines what a reasonable person should do. It is the law. And the UGI has the correct standard. The one case we have from which this UGI was created, and by the way, the UGI is the thing that was approved by the Supreme Court after the Mantelli decision. And they chose not to put reasonable police officer in the same circumstance. The UGI says reasonable person in the same circumstance. And I think the Mantelli case is instructive for this court. Let me get past, there's the Mantelli decision. That's what, I think at one point, Mr. Bregman said, Mantelli, Mantelli, Mantelli. I say, Your Honor, yes, I think there are some instructive things in Mantelli, and I'd like to compare the facts of Mantelli to our case. Because in the Mantelli case, Judge, the court found, even though it reversed it and said you need to go back and give a justifiable homicide instruction, they were also asked to look at whether the facts in that case were sufficient for conviction on voluntary manslaughter and aggravated battery by the police officer who shot into a car and killed a man. And what it says is oops, let's see if I can read it off of here. We reviewed the record and find that there was substantial evidence to sustain the defendant's conviction, even under proper instructions. That is, sustain a conviction beyond a reasonable doubt. Not probable cause, but something to sustain a conviction. So what were the facts of Mantelli, and what are the facts here? In Mantelli, there were 2 suspects, not 1, like there were in this case. In Mantelli, there were 2 officers facing 2 suspects, not like here, where there were 19 officers facing 1 person. In Mantelli, the weapon was a car, a moving vehicle, with which he tried to run over the officers. In this case, it was 2 pocket knives, which for most of the encounter were kept in Mr. Boyd's pocket. In Mantelli, there was an escape risk because he had led these officers on a high-speed chase. They were concerned that he would get out into the community. In this case, Judge, no escape risk. He was surrounded. According to Sergeant Fox, he was going nowhere. There was no escape for James Boyd. Proximity, close, he fired from 1 arm's length away. In the Mantelli case, here they fired from 10 to 20 feet away, depending on whether it is Officer Sandy or Officer Perez who was firing. The defendants in that case claimed the same thing the officers claimed here. They felt shocked and scared. They thought they were backing over his partner. There were potentially others in the area. Same thing as here. Perceived threat, thought they might come at them, potentially others in the area. Warning, there was no warning in Mantelli, something that the court criticized. And something that should be criticized here. Because if you recall, when the field officers were there, they told Mr. Boyd what they had was a beanbag shotgun, non-lethal round, and said to him, if you cross this line, we're going to shoot you with a beanbag shotgun. Then they were called off, and they were replaced by the tactical team, the rope officers, the canine officers, and the SWAT officers who were arriving late to the scene. No one ever told Mr. Boyd at any time on that tape that they now had lethal weapons, or that they would use them against him, or they would shoot him with a lethal weapon rather than a non-lethal weapon. Also, when he pulled out the knives in response to the dogs in a defensive gesture, nobody said, get on the ground or we're going to shoot you. No one said that. They just told him to get on the ground, get on the ground. And even without the threat of shooting him, he got on the ground. He did what they said. Finally, the defense was that it was self-defense and protecting the other officer. That's the same thing they're claiming here. In this case, the court found that it was justified in our case, where he is less dangerous than were the suspects in Mantelli. The shooting is less justified. I mean, when you compare the facts, this would be a more dangerous suspect and a more justified shooting, and this would be a less dangerous suspect and a less justified shooting. What did they say in Mantelli? They said there were sufficient facts to convict beyond a reasonable doubt, and in this case, Judge, under the lessened standard of probable cause, that is just slightly more, 51%, there are sufficient facts to indict in this case. Again, I want to focus on the reasonable person standard. I think this is the thing that the court has been quoting, saying you look at the acts of the officers, not their training. Defendant has presented evidence that at a certain point the suspect presented a real threat to him and others. Whether that threat had dissipated sufficiently by the time he fired the fatal rounds to make his use of deadly force unreasonable was for the jury to decide. And that's almost the exact same situation we have here. The jury has to decide whether once Mr. Boyd turned away to follow the officers, the orders of these officers, whether he should be convicted. Just as the police officers should not be above the law, they should not be beneath its protections. The court understands that should you bind these officers over on probable cause on these charges, they will still be entitled to have a jury of 12 persons hear the matter, and all of them will have to decide beyond a reasonable doubt whether or not these charges should stand and they should be convicted. At this point, the court has ample evidence to find to find probable cause at least, that they should be bound over on the charge of second-degree murder, voluntary manslaughter, aggravated assault, and aggravated battery with a firearm. Thank you, Judge.
All right, thank you.